in the matter of process and industrial developments against the Nigeria.
This appeal is the culmination of a sorry tale involving human greed and corrupt practices. The appellants, whom I will call P&ID, entered into contract with the respondents, the Republic of Nigeria, whom I will call the Republic, for the construction of a gas processing facility in Nigeria. After disputes occurred, P&IG commenced arbitration proceedings against the Republic and obtained 2 awards, which amounted in total to $6.6 billion US dollars plus interest at 7%. That interest increased the aggregate value over time to over 11 billion US dollars. In 2018, P&ID brought an application in the Commercial Court in London to enforce the Arbitration Awards in England. The Republic defended that application. This involved a trial of between 7 and 8 weeks, in relation to which the Republic incurred unassessed costs of £44 million. Mr. Justice Knowles, in a judgment dated 23rd October 2023, set aside the awards under Section 68 of the Arbitration Act 1996 on the ground of serious irregularity affecting the awards. In particular, he found that P&ID had used corrupt practices involving a member of the legal staff of the Republic to obtain the contract on terms which were disadvantageous to the Republic, and had used similar corruption to obtain advantage in the conduct of the arbitration. Mr. Justice Knowles identified the serious irregularity as being that the awards had been obtained by fraud, and the way in which they had been obtained and their enforcement were contrary to public policy. He subsequently ordered P&ID to pay the Republic's costs. The subject matter of this appeal is whether the costs should be awarded in pound sterling or in the Nigerian currency, the naira. P&ID argued before Mr. Justice Knowles that, although the Republic had been billed by their English legal team in pound sterling and it had paid those bills in sterling, the costs should be awarded in naira on the basis that the Republic had funded their payments to their English solicitors by converting naira in its consolidated fund into sterling. That assertion was disputed. The P&ID argued that the award of costs in naira most accurately reflected the loss suffered by the Republic in funding the litigation. Otherwise, it was submitted, the Republic would obtain a windfall at P&ID's expense because, since it had paid its lawyers, the value of the naira had fallen markedly against other currencies, including sterling. The sterling amount which the Republic had paid its English solicitors was, at the time of payment, the equivalent of 25 billion naira. Now, it would be the equivalent of 95 billion naira, an almost fourfold increase. Mr. Justice Knowles rejected this argument and awarded costs in sterling. His judgment was upheld by the Court of Appeal, who held that the English solicitors had invoiced the Republic in sterling and it had paid those bills in sterling, and the cost award should be in sterling. P&ID now appeal, the Court of Appeal upheld that finding, and P&ID now appeals with permission of this court to this court and renews the arguments which it advanced in the courts below. This court unanimously dismisses the appeal. In a judgment prepared by Lady Simler and myself, with whom Lord Reid, Lord Stevens and Lord Richards agree, 4 reasons are given for that judgment. First, an order for costs is not intended to provide compensation for loss in the way that an award of damages in tort or for breach of contract is. Secondly, an award of costs is a discretionary remedy determined by reference to all the circumstances. It needs to identify a reasonable amount which the paying party should pay to the receiving party as a contribution to the latter's costs. and not to put the receiving party in the position it would have been in if there had been no litigation. Thirdly, in most circumstances, the court does not know how a litigant has obtained the funds to pay its legal fees, and the court does not investigate those arrangements with a view to ascertaining a party's loss. And fourthly, such an investigation would risk creating collateral disputes of fact which might require a separate trial. For pragmatic reasons, the court would not adopt a principle which would encourage disproportionate and expensive additional litigation. In this case, there was a factual dispute as to how the Republic had funded its sterling payments, and that would have required to be resolved by a further trial. The court observes that there is no requirement in statute, that's the Senior Courts Act, or in the Civil Procedure Rules, that costs orders must be made only in sterling. It is consistent with legal certainty that there should be a general rule that costs be awarded in sterling or in the currency in which the solicitor has billed the client. That rule could be departed from if a party's choice of currency was abusive or inappropriate. For example, if a party or its lawyers chose a currency with which they both had no real connection and were seeking to make profit from currency fluctuations. If it were to become a common practice for parties litigating in England and Wales to pay their lawyers in a currency other than sterling and seek to recover their costs in that currency, consideration would need to be given to a practice direction to safeguard the court's methods of costs control and to protect the paying party from currency fluctuations. In this case, there is no reason to award costs in a currency other than sterling. Mr. Justice Knowles did not err in law in the exercise of his discretion. Finally, the court observes that the Republic will not enjoy a large windfall by receiving an award of costs in sterling, as the depreciation of the naira in recent years has resulted in imports costing much more and in significant domestic inflation. The appeal is dismissed. The court will adjourn.